It's a great honor for me to be here today. The problem with the topic that was assigned to me is that it will demand in and of itself a two-day conference. I will try to be brief. Originally it was 30 minutes, now it's down to 30, so I'm afraid that there will be a part on reparation that I will not be able to address, but I will address it in my written contribution. This being said, what I'm going to express today is, of course, my own ideas of what is going on at the court regarding victims' participation and reparations. And as Eva kindly introduced myself, you would have understood that these ideas have been forged by my almost 20 years working for the court, which gave rise to a lot of hope, but also a lot of frustrations. I will, since it seems fashionable to quote people, I will quote President Hofmansky, the president of the court, in his general address before the UN General Assembly in 2022. He highlighted the fact, and I quote, that the ICC has ushered in a concept of international criminal justice that gives victims a strong role in the process. And he later specified that, I quote again, the court invests a great deal of time, energy, and resources into making the victim-centered vision of justice a reality. Now, what we are going to do in the next 20 minutes is going to see whether this is actually a reality from victims' perspective. I will now start by hopes, by way of lesson learned, to paraphrase the theme of the conference. As you know, victims have long been ignored by international criminal justice, and it is only with the adoption of the Rome Statute that victims were placed at the very heart of international criminal justice, since the statute recognized for the first time the possibility for them to participate in the proceedings before an international criminal jurisdiction and claim reparation for the harm they have suffered. And indeed, one of the main innovations, and sometimes even referred as to a revolution of the statute, was to shift the role of the victims from mere witnesses supporting thesis of either the prosecution or the defense to a real participant in the ICC proceedings, meaning real participant being an autonomous participant, not linked either with the defense or with the prosecution. So in doing so, they participate in an independent manner, benefiting from rights, but also from obligations. Now, it is very striking that from the beginning we knew that participation of victims and the full recognition of their rights will not be an easy task. And this is so because you might have noticed that the term victims is used, I think, 39 times in the statute, but the definition of this term only intervened after the adoption of the rules of procedure and evidence 4 years later. So that was not a good sign. But it can be easily explained by the fact that you had a dichotomy between common law countries not knowing anything about participation of victims and civil law countries. And it was a harsh consensus reached at the Rome Conference, which explains this lack of definition. But one can wonder really why it was so difficult, because basically the definition adopted 4 years later is largely based on Article 1 and 2 of the Declaration of Basic Principles of Justice for Victims of Crimes and Abuse of Power, which was adopted by the General Assembly of the United Nations in 1985. In the same vein, except for providing that victims participate in the proceedings by expressing, and I quote, Article 68.3 of the statute, views and concerns, and from assigning specific rights to victims at specific stages of the proceedings, the legal instruments of the court do not provide details on the modalities of participation of victims in the proceedings. Accordingly, the participation itself was largely left to the interpretation of the statutory provisions by the judges and also by the legal representatives of the victims who are responsible for representing their interests. Since each and every chamber was going to define their own the modalities of participation of victims, one could have feared that these modalities would be different in each and every cases. Hopefully that was not the case, and there were a lot in common, except for strange variations, but over the years, I think we can easily say that the modalities are quite similar in each chambers of the court. I have to say, because I referred to the fact that this issue of victims' participation and the definition of the term was linked with the opposition between common law and civil law, but it's very important to notice that the first participation of victims' decision before the court was issued by a chamber presided over by a British judge. So hopes were at that time the key words when referring to participation of victims. Now, I do not intend to say that it was all very easy, and it was actually not easy. At the very beginning, it was all new, and there were some harsh discussions over the issue of participation of victims introduced in the Rome Statute. The first challenge was to establish that the principle of victims' participation as such was no longer questionable. And as legal representative of victims, we had to shift the attention of detractors, including in particular all defense teams before the court involved in pending cases, to the implementation of these rights themselves. The large number of victims seeking to participate, the delay possibly induced in the proceedings by the review of such requests of participation and the subsequent participation of victims are, of course, amongst the concerns that were most often expressed. These concerns triggered various measures, and I'm not going to enter into this, the detail of these measures, but victims, in order to participate, need to fill out forms that later are transmitted to the relevant chambers. These forms, the defense and the prosecution are allowed to make observation on these forms. They were always saying that it was very time-consuming, that it was resource-consuming as well, and as a result, they were given additional resources to do so. Nowadays, this is not really true any longer because of the new approach by the judges referred to as ABC, so it's not as time-consuming as it used to be. At the same time, some chambers' rulings were at least partly responsible for the all too frequent criticism against victim participation, the fact that it is time-consuming, and hopefully these rulings have been simplified. And for example, I will refer to the practice established by the Appeal Chamber and applied consistently until 2015, whereby victims wishing to participate in an interlocutory appeal would not have an automatic right to do so before the Appeal Chamber. For legal people, it's clearly something that is not understandable, except for judges of the Appeal Chamber. And we tried to have this jurisprudence reverse every time there was a change in the composition of the Appeal Chamber, but again, it was sustained again until 2015. Nowadays, thankfully, we do not have to apply for each interlocutory appeal, and the rights of victims is automatic. In addition, the role played by victims and their legal representative has itself been the subject of controversy. For example, all defense teams routinely put forward that the proceedings are not fair because they have to face two prosecutors, the real prosecutors, and the legal representatives of victims. And that would, according to them, be contrary to the right of defense and the right of a fair and impartial trial. However, I have to, and this will not be a secret, I have to state that this is totally not the case, because victims represented by their lawyers are clearly distinct from the prosecution. Of course, their interests often converge, in particular concerning the discovery of the truth and the prosecution of the perpetrators. But I don't have time to enter into a lot of examples, but I can definitely tell that we do sometimes oppose the prosecution. For example, when it comes to the decision of the Office of the Prosecutor not to open an investigation, which was the case, for example, in the situation on the registered vessels of the Union of Comoros. And in the Ntaganda case referred to yesterday, not only, as you know, the judges recognize that you can suffer sexual violence as a military inside your own militia. And again, I state before you, because in my next part I will be very, I will critique a lot of judges' decisions on participation of victims, but as a practitioner, I can definitely recognize that this is an advancement of humanitarian law by the judges of the International Criminal Court. I didn't, however, succeeded in fighting the position of the prosecutor, which is that the international prohibition of rape and sexual slavery against recruits was only covering child soldiers. So meaning I was trying to have the judges recognize that it should also cover all women in the militia, but clearly opposing the prosecution, but I didn't succeed. Now, everything is beautiful, victims can participate, but what is actually the case today on the effectiveness of this participation? And this would be my second part on frustrations that should definitely be considered as lesson to be unlearned. So the principle of the participation of victims in international criminal proceedings, again, is no longer in dispute, and is it really effective? Despite President Hofmansky's address before the UN General Assembly, referred to in my introduction, today the court does not in reality appear to be truly victim-oriented. One important frustration for the victims, and as a result for their legal representatives, for that matter, derive from the founding texts themselves. Indeed, what may seem again to be an aberration, even to layperson, is that victims cannot request leave to appeal decisions that impact their personal interests. Indeed, this possibility is only offered to them with regard to the reparation orders issued by the judges. Now, it means basically that they cannot request leave to appeal or appeal decisions denying authorization to open an investigation or not granting applicants' victims a statute to participate in the proceedings, or again, they cannot appeal decisions by the prosecutor not to open an investigation, which clearly impact their rights to justice. They rely for that on the prosecution, and sadly, the prosecution not always, again, follow their direct interest. Most of the frustration faced by victims today are sadly also the results of decision of different chambers. And I'm sorry because I'm speaking in front of Judge Kovacs, who was left alone since Judge Schmidt is not present. But again, I remind you that the only possibility for a legal representative of victims to criticize decisions issued by judges, since they cannot appeal, is to be able to address these critics in conferences such as today. So, as he was putting it, there will be only friendly critics, but critics nonetheless. Because of the time that was allocated to me, and it's going fast, I cannot go into a lot of details, but I will, again, if you are interested, do so in my written contribution. As Judge Kovacs was referring to yesterday, of course, it's the frustration of victims can be noticed, for example, as of in June 2018 with the Bemba acquittal, but not because of the acquittal itself, but because these acquittal intervened after reparations were underway for 2 years, and after the initial convictions, and after 4 years after the closing of the trial. Now, an acquittal is always a possibility in international criminal proceedings, and I myself prepare all my clients for this possible outcome. But the length between the closing and the trial, the starting of the reparation proceedings, and the eventual acquittal was an issue. But it is nothing compared to the acquittal of Mr. Gbagbo and Bligoudet in January 2019, which is much more problematic because the reasoning for such acquittal was issued 5 months after the decision to acquit. Now, you have to understand that as a legal representative, not being able to explain for 5 months such an important decision is clearly not admissible. In the same vein, there were other decisions, such as, for example, the pretrial Chamber 2 decision not to authorize the prosecution to proceed with an investigation in Afghanistan. If you don't know, the Chamber made a positive finding as to the court jurisdiction over the crimes allegedly committed, but decided that an investigation would not serve the interest of justice at that stage. Well, this is clearly not a sign that the court is victim-centered, to paraphrase Judge Ofmansky again. In addition, decisions on participation in the proceedings and on common legal representation are often adopted by chambers at a very late stage. I'm not going to dwell too much on this issue, but just to demonstrate this point, I will base myself on decisions appointing myself in the Ntagonda case. The decision concerning the participation of victims at the pre-trial stage was adopted on 15th January and 7th February 2014, while the hearing on the confirmation of the charges started on 10th February 2014. Now, in the Said case, I was appointed to represent the victims at the confirmation of the charges hearing on 6 October 2022, only 6 days prior to said hearing. Now, you have to understand that representing victims is just not something you do out of a magician hat. You need to meet with your clients. You need to read the documents, and this is very complicated when you are appointed 6 days prior to the hearing itself. Further, chambers often set very short deadlines for submitting observations on the parties on issues directly affecting the personal interest of victims, such as, for example, the request for release of a suspect or an accused, or issues concerning the court's jurisdiction and the admissibility of cases. This often makes it totally impractical for legal representatives to consult with their clients because, again, our clients, contrary to the defense client, which is like 500 meters away from the seat of the court, are residing in the situation countries, in very remote areas. And when you have only 10 days, and often this 10-day deadline is often reduced by judges, it's very complicated to consult your client. There were, further to these direct threatening decisions on victims' rights, you now have a trend to adopt very restrictive approaches concerning the scope of the charges. And according to me, this new approach are not taking into account the real victimization and the scope of victimization. For instance, in the Said case, the trial Chamber 6 ruled that the charges are limited to a specific number of events described in the decision confirming the charges, even though the pre-trial chamber itself clearly stated that there were mere examples. But as a result, because of this approach, we are now in a situation where, if applied to the end, to the fullest by the chamber, only witnesses will be able to participate as victims in the proceedings. And this is clearly very far away from real victimization in Said's case. Now, I need to go I could go on for hours, and I will gladly answer your questions. Yes, now it's dead to me. I will gladly answer your questions at the end of this session. But it suffices to say that the new trend seems sadly, clearly to be for judges to assert principles, but not to allow for the possibility for victims to effectively enjoy the rights recognized as principle. I surely hope that this will change, but this is today the situation. Thank you very much.